Good afternoon and welcome to the webinar. This is Roger Royse, the founder of the Royse Law Firm, a business, corporate, and tax law firm with offices in Northern and Southern California. So today we have invited a leading judge, arbitrator, and mediator to help guide you through the process to determine which form is best depending on your needs in dispute resolution, courthouse, arbitration, or mediation. With us today we have Duf Sundheim. He has over 30 years of experience resolving disputes involving companies such as Disney and NBC Universal, public issues working with current and former governors, mayors, and other high-ranking officials, high-tech companies with complex issues, the NFL, and some nonprofit groups. He works closely with leading public officials to address major issues of the day, and Duf's mediation practice focuses on contracts, real estate, intellectual property, securities, investments, public disputes, and professional and amateur sports. He is at gpsmediation.net. We also have Judge Gerald Buchwald. He's a judge of the Superior Court of San Mateo County. He frequently conducts mandatory and day of trial settlement conferences in all kinds of civil cases, simple to complex. He serves as the civil law and motion judge and tries both criminal and civil cases, jury, and bench trials. His assignments include general civil trial department, law and motion calendar, complex civil cases assigned for all purposes, case management calendar, and the settlement calendar. He's handled criminal trial calendars, including hearings in felony cases and both felony and misdemeanor trials. And finally, we have Justice Fred Morrison, who joined JAMS in 2009 after serving 9 years in the trial courts and over 14 years on the California 3rd District Court of Appeal. Since joining JAMS, he has mediated, arbitrated, and served as a special master and discovery referee in a wide variety of disputes. He's the Ninth Circuit representative on the Board of Trustees, American Inns of Court Foundation, and teaches a course in arbitration at the University of Pacific George School of Law. So again, I'm Roger Royse. This is our webinar series. I want to thank you all for coming. Today, for today's webinar, I think what we're going to do is going to go ahead and launch into a presentation, and it'll be a little bit more informal than our typical practice. The panelists will discuss each of these slides that show up on your screen, and if you have questions, you'll notice a dialog box in the upper right-hand corner. Go ahead and type your questions into that dialog box, send it to us, and we're going to go ahead and take questions in real time. And if we have time at the end of the hour, we'll go ahead and collect a few other questions so we can have a little bit more back and forth. I want to let you know that this webinar is being recorded, and at the conclusion today, you'll be able to find it, post it, along with the slides, on our resource site, royseuniversity.com. It'll also be on the Royse Law YouTube site, and it'll be available as a download, as a podcast in the iTunes iStore. And with that, I'm going to turn it over to you, Tom.
Thank you, Roger, and thank you to everybody on this webinar for participating. On the slide in front of you, you see 3 mugshots, just so you can help keep the people straight. I'm the guy in the middle, Duf Sundheim, and on the left is Justice Fred Morrison, and on the right is Judge Gerald Buchwald. What I'd like to do is just start out with a general description of the 3 types of forms we're going to be discussing today. One is mediation. That's the situation where the hearing is held in front of a mediator. That mediator has no control over what decision is reached. The determination is made by the parties. The second form we're going to discuss is arbitration. There you have somebody who is not a judge, but they do typically have the power to make the decision in the case. And the third is actually the courtroom, the one that we're most familiar with, and that is where the judge makes the decision. So those are the 3 forms we're going to be discussing today: mediation, arbitration, and the courtroom. So let me just talk a little bit about mediation to kick off the discussion, and I'm going to bring Jerry and Fred into the conversation shortly. And again, as Roger indicated, please send in your questions. We really find that that's the most interesting use of our time, is responding directly to the questions and comments that you have. about the topics that we're discussing today. When I think of mediation, when I'm sitting down in front of parties in a mediation, I start off by talking about the 3 C's of mediation. And those 3 C's are control, cost, and conclusion. With respect to control, the mediation process is the last step in the process where you have control over the decision. When you're done with the mediation, whether you go on to an arbitration or whether you go on to a judge, those decisions are going to be made by strangers. Those decisions are going to be made by people that aren't as familiar with the case, the facts of the case, as the participants. So this is the last opportunity that you really have to have total control over what the decision will be. The second C is cost. The financial costs that you will have occurred up to the day of mediation can be substantial, but they are nothing compared with what the cost will be after the mediation. There's kind of this hockey stick increase in the financial cost of mediation. And that's just the financial element of the cost. The emotional cost is usually even higher. So I explained to the participants that as difficult as it's been emotionally up to this point in the process, the emotional cost is going to be even much higher after the mediation. And third, conclusion. When you walk out the door, you will be able to put all this behind you. You will have stemmed all of the costs, both emotional and physical, and you will have a resolution of your dispute. Jerry or Fred, do you have any comments on the 3 C's that you'd like to make, Jerry?
Well, I think the control point is an important one, and I base that on the fact that in about 40 years of working on civil cases, the parties that resolved their case, while they still had control, either in a mediation or in a settlement conference at the courthouse, are much happier than those that took their cases to trial, because trial is unpredictable, and the truth is there are many compromise results, and it's very unusual for somebody to go to a court trial and get a 100% recovery for their side of the case.
Fred, anything you'd like to add?
Yeah, thanks, Duf. I think one of the critical things to think about in a mediation is when do you do it? And the sooner you do it, the less money you've spent on litigation costs and depositions and other discovery and so forth. On the other hand, if you do it too soon before you know enough facts, it's been my experience, it's very hard to settle a case when too many facts are unknown and there's too much dispute about the facts. So it's always a balancing test between doing it early and saving money, but maybe not succeeding because you haven't done enough to have enough information to have an effective mediation.
Well, this is Duf again, and I couldn't agree more, especially in the area of trade secrets. You may have a situation where you have complicated legal issues that are on the table. And a lot of times I find that people get into the mediation too soon where they don't know where their judge is going to go with respect to a legal matter. Or you may have a situation where you're waiting on a decision from the Second Circuit or the Ninth Circuit as to an issue of law. And so sometimes I think you're right. You want to do the mediation as soon as possible to keep the costs down, but I also think it has to be the right time in terms of having an understanding of what's going on from a legal perspective. Jerry?
Yeah, there's usually two things that will cause a mediation to be unsuccessful, and that is disputed facts or disputed law. Now, sometimes you could start a mediation, and when you identify those things, you can recess it, do a critical deposition, or even do a law in motion matter and get a decision, and then come back and settle it.
Jerry?
You know, I think the audience, I understand, is somewhat mixed between lawyers and business people. And one thing that audience members might not realize is that in the mediation is probably your most flexibility for private discussions with the mediator. Not everything is in a joint discussion where all of the parties or all of the lawyers, if there are lawyers involved, are present. And you can share things with the mediator that at least for a time may not be disclosed to the other side. And it may be armed with that information that the mediator, without a full disclosure of it, will be able to use that in a way to conduct the negotiations to bring about a good result.
Well, that's a good point. Let's go to the next slide where it says mediation, and we have trust, confidentiality, and evaluation. I think Jerry's raising the issue of confidentiality. Fred, would you like to weigh in on that issue?
Yeah, I would, because Jerry raises an interesting point. It is confidential, and I'll have people tell me that, hey, I don't want you to tell the other side this. And I tell them, well, good, I write it with my red pen. Well, you never want to break that confidentiality. On the other hand, sometimes you find you're trying to settle two different cases because each side has this powerful evidence that they would like to hold back, but if the other side only knew about it, they'd probably settle. So I often try and get them to give up the confidentiality so the other side can be aware that there's a strong case against them, and then be motivated to settle the case. Like so many things in mediation and all of this, it cuts both ways.
And Jerry, tell us a little bit about the issue of trust and what the role of trust is in the mediation process.
Yeah, I think that one of the most important mistakes that parties, if they're representing themselves or lawyers that are in mediation and in court-conducted settlement conferences that I'll talk about a little later, is that they won't put trust in the mediator or the settlement conference judge and share as early as they can where they want to end up. And after a lot of years of doing this as a lawyer and as a judge, I think that the best thing that can happen for both sides is if the mediator knows what the target is. And if you know that, if you're ever conducting any talks like this, at least you have something to work with where you have some feel for where do people want to end up. And sometimes those goals pass like ships in the night, and it turns out that there's room in the middle for a settlement. But you can't really see that unless people are willing to trust you with what their agenda is. Where do they want to end up?
Fred, one of the things that I think a lot of people that aren't really familiar with this whole process miss, that's the issue of evaluation. What is it? When is it appropriate? I wonder if you could spend a couple minutes explaining that issue to us.
I will, and let me just talk about the general mediation process for those that have not participated in a mediation. Is that the mediator is really trying to facilitate the settlement, and the power the mediator has is he or she is neutral, and if trusted by the parties, and the mediator gives an evaluation or gives a number, it will come across much less threatening than the same numbers, the same information coming from their adversary, who's obviously has an interest and a point of view. And so, as Jerry said, first you've got to get the trust, and that often comes simply from discussing the case, asking questions, learning about the case, building rapport. And then in some mediations, they don't want an evaluation. They just want to talk about the case and then start negotiating. But oftentimes, particularly if the mediator is a retired judge, they hired you with the idea that at some point you'd give an evaluation and tell them about the case. Who's going to win, in your opinion. And the problem with that is if you walk in the door and say, well, the plaintiff has a very weak case and the defense is overwhelming and I think you should take $5,000 and get out of here, well, they're just going to shut down, and it's not going to happen. So you need to probe their case, ask difficult questions, and maybe initially simply evaluate, for example, well, I don't know that you could prove this element. What's your evidence going to be? Will that evidence get in? I think, you might have trouble getting some of this in. Those kind of mini evaluations. And toward the end, when the numbers are getting closer, they may say, well, what do you think, Judge? What's going to happen here? And, you can't tell them that, well, I think you've got a 76% chance of winning. That just cuts it too fine. Generally, what I'll do is a strong case is one you would win 8 out of 10 times. A weak case would be the opposite. You probably win it twice out of 10. And then there's the 50-50 case. So those three broad categories are probably where you're going to put their case. But the critical thing is, when do you do that? And the first thing is, you don't do it too soon. And you probably do it when you've had a thorough discussion of the case and you're very familiar with it, and you can, because just telling them a figure for most lawyers is not going to do it. They want to know why you think that. So you need to be armed by this time with good reasons that you can tell them why you think their case is weak in certain areas, and why perhaps they ought to then modify their demands. It's kind of an art.
It absolutely is. And so we're going to get back and talk more about mediation later in the presentation. But right now we're going to flip to the next slide, which discusses arbitration. And Justice Fred Morrison will lead us in the discussion on arbitration. Judge?
The thing about an arbitration is what you do when both sides have agreed that for a variety of reasons they would rather not have their case tried in court, either in front of a jury or a sitting judge. They would like to select the trier of fact and agree on one, and have that person try it in an informal setting, usually in a conference room. And the goal of an arbitration is usually to have it be done more quickly, and even though you have to pay your judge, the arbitrator, less expensively. And we'll talk about that in more, because there's some disputes about whether it actually works that way anymore. But one of the keys is that the arbitrator can then manage the case and move it along, and without all the conflicts, both on a calendar schedule and on a daily schedule, and you can get it done much more rapidly. That's the purpose of it. Along with the arbitration comes a set, normally if you select, say, JAMS or American Arbitration Association or any number of providers, they'll have a list of procedural rules which will govern the arbitration, unless the parties decide they would like to have some different rules or change rules. And the parties can do that. That's, once again, the key to an arbitration is you've agreed to do it, and you can agree to what the procedures ought to be. That's the law of an arbitration is the contract between the parties. And many times they will refer to rules of an organization, and then those rules become a part of the law of the arbitration as well. But the whole idea is to get it done out of the court system quickly by a trier of fact who may have the expertise you're looking for. You're not taking the risk of getting a judge, for example, who has done nothing but criminal until today, or something like that. And when it's done, it's done. It's over. No appeal, which is both good and bad.
That's very helpful. And again, we'll get back into more of the arbitration. When is it appropriate? When's mediation appropriate? But we thought we'd do now is go to the next area, which is the courthouse. And a lot of people, when they go to the courthouse, the image that they have of the procedure is much like the picture that's now on your screen. Let me assure you that is not a picture of either Judge Buchwald or Justice Morrison, but it's just a depiction of how many people feel. So with that introduction, let me move on to the next slide. And we'll now hear from Judge Gerald Buchwald, or is known to his friends as Jerry, who will talk about the court system itself and really focus on an area that's not, for those of you that are familiar with this, you understand the importance of the settlement process. But Jerry, why don't you talk, first of all, what percentage of the cases actually settle relative to the number of cases that come in front of you, and then talk about the court process.
Well, if you take all civil cases that are filed, the vast majority of them will settle. The number of cases nationwide on the civil side that get tried is something less than 5%. So the vast majority are going to settle either in a mediation that's privately done or by a mediation that's referred by the court, or in settlement conferences that a judge will conduct at the courthouse. And throughout California, there's a little variation from county to county, but every county has a mandatory settlement conference, usually close to the trial date, roughly 2 to 3 weeks before the trial. And in our county, we always have, when something comes up for trial on a master calendar, the presiding judge will send it out for a day of trial settlement conference to another department that is not going to be the trial judge. And the dynamics of that are similar to a private mediation. You will usually be in the judge's chambers, not out in the courtroom. The court rules require, but even if they didn't, if you go to one of these, you should have the people there that are the decision makers. I think it's foolhardy for parties to have someone other than the lawyer who's actually going to try the case there. If you're a large company and there's an in-house counsel who really is making the decisions on what should be done with the claim, that person should be there. Or if it's an insurance company that has a claims representative, the senior person who really is going to make the decision ought to be there, because otherwise the judge can't do much with the case. And clients with real authority need to be there. The main difference between the private mediation and the courthouse settlement conference, I think, are two things. One is that if you do reach a settlement, you've got the court right there, and a reporter can be brought down, and a record can be made right there in the courtroom of what the deal is and what its terms are. And what's important there, among other things, is that either the lawyers or the judge make sure, by asking the clients directly, if they understand all the terms of the settlement, and do they agree those terms, and confirming that they have the authority to agree those terms. And if that's done, then the settlement later, if it isn't honored, can be enforced. And I'll probably talk about that a little later, but there are ways, both by motion and by other proceedings, to enforce the settlements. The settlement conferences have the same dynamic as mediation that Fred was talking about earlier, and that is that there needs to be a level of trust with the judge for the judge to get anything accomplished. And the other thing I'd say, in line with what Fred said a little earlier about mediation, is that you have, if you're in the chair of the person conducting one of these settlement conferences, people come in and they love to talk about how great their case is and how wonderful their case is and how the other side's case is terrible. And what they're not focused on is, what are the problems in my own case? And one of your jobs as a good settlement judge, in my opinion, one of your main jobs is to say to the folks, look, I understand about the strong points of your case, but let me point out to you some weaknesses that you have. Have you really thought about these things? And that is a very important dynamic in the settlement conference itself.
When you're doing a settlement conference, about how long would you have for each case?
On the day of trial, I'm going to have the morning, and if I think that I'm getting somewhere and I tell the presiding judge that, and I have to have a good track record of credibility with the presiding judge on that, maybe he or she, the PJ, will let me keep it into the afternoon.
Well, that's excellent. Yeah, when I did settlement conferences in the Superior Court, we would have 4 cases in the morning and 4 in the afternoon. And the problem is, of course, you simply don't have the time to do the evaluation that you're talking about.
Well, on the mandatory settlement conference calendar, you could have 4 a day like that. But they're not going to all, require the same amount of time, so you can manage them if you have to.
Now, the normal mediation, it can vary, but usually it will go all day long.
Right.
And the saying is that, well, you have all day, so it still settles at, if it settles at all, it settles at 5 o'clock or 5:30. If you had only half a day, it would settle at noon.
Years back when courthouses were different and you could legally drink in a courthouse, the judges in our county had their, quote, medicine cabinets. And if you settled, and in those days, security issues were different. And the judges would keep you there for all hours. And I'm talking about till 11, midnight, 1 in the morning. I remember settling a case in Contra Costa County at 2 in the morning, and to seal the deal, the judges would break out the scotch, and that's what would happen. In some ways, a better and more civilized age than we have now.
I once went to a veteran judge who was known to be a good settlement judge and asked him if I could sit in. He said, sure, and I went up there at 4 o'clock. And for 2 hours, he sat there telling war stories and smoking. And eventually, the lawyers said, if we could step out in the hall, Your Honor, I think we could settle this. And they did.
Everybody has their techniques. Well, we'll get back to that. Go ahead, Fred. Is there something you want to add at this point?
Let me see here. No, I think I had my say interspersed in there.
Great. So the next slide has a picture of one of the iconic coaches in football. And when he was at Stanford, I had the opportunity to work with him and to see what his technique was. And I think it was a technique that is equally applicable to those of you that are facing a court. What Bill Walsh would do at the beginning of the season is he would sit down and figure out if he was with the 49ers, what it was going to take to win the Super Bowl. If he was at Stanford, what was it going to take to get into a bowl game? And then he would figure out what it would take to win the 11th game, the 10th game, the 9th game, and he would run it all the way back to the first practice, and then he would have drills in that practice that were designed to help him win that eventual goal, whether it was the Super Bowl or a bowl game. And I think that's the thought process that is really helpful to you as you enter into a dispute. A lot of times people just go one step at a time. They're thinking tactically, okay, I file a lawsuit, I ask for the deposition, without really thinking what their end game is. And I think all three of us strongly recommend, before you take the first step, that you visualize what do you want to achieve and which of these 3 forums provides you with the best opportunity to achieve that result. So that's what we're going to get into now. When is it best to use arbitration? When is it best to go to the court? When is it best to go to mediation? So with that in mind, Fred, why don't you start off the conversation as to when you think it's best to go to the arbitration?
Okay. Now, probably the primary difference that you note right away is that in an arbitration, there is no jury. So if you have a case that has large emotional components or you're counting on jury sympathy, then obviously arbitration is not the way to go. Generally, for business disputes, particularly complex business disputes, when you're looking for the ability to select your trier of fact, somebody that has the kind of experience and reputation that you would feel comfortable with, arbitration gives you that ability. If you have a need to try it quickly, and get it over with. Perhaps you have a continuing relationship in a contract situation and you want it to go on. If a arbitration is managed properly and if everybody is on board with the idea of doing it quickly, it can be done very quickly. Not only can you schedule it quickly, but generally I'll arbitrate from 9 in the morning till 6 at night with an hour for lunch, and you can do an amazing amount of work in that time. Probably 3 times faster than a trial with all of its interruptions. If you want it to be over with, the normal rule in an arbitration is there is no appeal, and so you get a verdict and it's done. Now, that may make you nervous too. If it's a big bet the company case, you may want to be able to have the safety of an appeal. So that's something to think about. And of course, if you're in court, you could have the appeal. You could have an arbitrator who was appointed by the court as a judge pro tem, a judicial reference, and maintain your right to appeal. And there's a big dispute between the California and the United States Supreme Court about whether you could agree in an arbitration to have it appealed into the public court system. The United States Supreme Court says no, and I think were it to come down to it, that would probably carry the day. The rules of evidence in an arbitration will be relaxed generally to, is it relevant and is it trustworthy? So you need to evaluate your case. If you have some critical evidence that you might have difficulty getting in based on, say, hearsay, in an arbitration you would most likely get it in. The arbitrator would simply give it the weight that he or she thought it deserved. And those are the primary differences. Selection of the trier of fact, speedier, maybe less expensive. You're paying the judge, but on the other hand, if it's done in less time, you may save money, and you do it and it's over with. And under the law, if the arbitrator even makes some legal errors, it will be affirmed by a court. The arbitration award will be confirmed. It's only if he exceeds his power or is corrupt or something like that that you can get it overturned. So those are the kind of things you need to think about when you make that decision.
That's a lot to think about. And while you're processing that, Jerry, why don't you tell us when, in your opinion, it's best to go the court route?
Well, I think that that really involves, to some extent, a comparison of what happens at the back end of each of these proceedings. And by that I mean that if you don't have a pre-existing contractual arbitration agreement and you're free to choose agreeing to go to arbitration, a mediation, or to keep things in a court-conducted settlement process, at the back end of each of those procedures, the result is in a different form. In an arbitration, as Fred said, you're going to get an award, and that can be confirmed, corrected, or vacated. And the grounds for vacating an award include whether it was procured by corruption, fraud, or other undue means. There's no case law, no appellate case law on what that last category means. And it's only come up a couple times in the things that I've heard since I've been on the Superior Court. Mediation is going to give you, so you're going to have this award, and you're going to bring it to the Superior Court. And the Superior Court, when it gets that award, if there's no problem with it in terms of corruption or dishonesty or this other undue means, you're entitled to have a judgment entered on that award. And you'll end up with an enforceable, collectible judgment. In a mediation, you're going to have, most likely, some kind of written agreement as the result of the mediation. I've seen them where they're handwritten out on legal tablets and signed by the parties. I've seen them nicely typed up and signed like formal contracts. You can have this done all kinds of different ways. But you end up with in effect, a stipulated agreement, or if the mediation is not successful, there may be filed in the courthouse a statement of non-agreement. And at that point, if you have not been successful, whatever you've done in mediation is what I like to call something that gets consigned to reside in the boneyard of forgotten and unmentioned things. Because by law, except for certain rare circumstances that are exceptional, the mediation of what goes on there is completely confidential. But at the same time, you can have, under a provision in the Code of Civil Procedure 664.6, you can have a settlement reached in a mediation outside the courthouse, and if the parties agree that that mediated result can be taken to the court on a motion to enforce it under the section I just mentioned, you can take it to the courthouse and get it enforced. And then with a court-supervised settlement, where everyone is right there, you'll have a record of the settlement usually. But on both that and a mediated agreement that's brought to the courthouse, the landscape you're on there is this, and that is that a judge who's presented with an application to enforce a settlement where someone's not performing it, either a mediated one or a court-conducted one that a record has been made of, that judge has broad discretion to enforce that deal, except for one thing, and that is that you cannot lawfully invent or create new terms that were not actually agreed. You have to enforce it as it was resolved and what the deal was. You can't rewrite the deal to be something else. So there are limits on that. But if you reach any of those three results, at the back end of this, I think most people assume that it's always the case that these results, whether they be an arbitration award, a settlement that's mediated, or a settlement that the court has conducted the negotiations, that's the end of the road. And in the vast majority of resolved cases, it will be. But there are some exceptions to that, and there are some of them that come back because people are not doing what they agreed to do. And right. So you have to think about which mechanism of enforcement do you want to be on.
Right. So Justice Fred, yeah, go ahead, Fred.
I just wanted to add one reason that I would take a case to court and not to arbitration is if I was looking to establish a legal principle, say you've got an environmental law case or something where you need an interpretation of a statute, and you know that you're going to end up, whatever happens at trial, you're going to go to appeal, and you may well get a published appellate opinion, perhaps even a Supreme Court opinion. If you're looking for that, then you need to go to court to get that. You won't get that from an arbitration. In fact, one of the public policy reasons I say that arbitrations, one of their negative effects, it's taken a lot of cases out of the court system and kind of in a way stunted the growth of the law a little bit because some important issues are being decided in arbitrations and there are no appeals, and so you're not getting any case law to flush out a lot of these business cases and some of the principles involved.
You know, in line with that, Fred, I think also something for us to mention is you need to think about the remedies that you want. Normally, an arbitrator is not going to have the authority to render any kind of injunctive relief, restraining orders, permanent injunctions, and certain other remedies normally given on the equity side of the court. An arbitrator cannot do that. And so in the private alternative dispute world, really the only normal remedy is money of some kind. And if you're looking for something other than monetary relief, then you really need to be in a court conducted either litigation or settlement procedure.
Well, I think that's right. And then, Fred, you also feel that there's a certain situation where you want to get in front of a jury. Do you want to just briefly tell us when you want to get in front of a jury?
Well, I mean, let's say, we had a case here a couple of years ago. It was an employment case, and it was apparently a pretty severe case, and they got in front of a jury. It was sexual harassment and other things in a hospital, and the jury came back, when you counted punitive damages, with an award of $168 million against a major hospital. Well, you're not going to get that kind of an award in an arbitration. Of course, ultimately, I believe it was reduced significantly, but it was still a huge award. I think with an arbitration, you're going to get a lot less emotion than you'll get with a jury. So if you're looking for the jackpot, you probably won't get it. On the other hand, if you're looking for a little more rationality, you might be better off in the arbitration. It's interesting, in medical malpractice cases, a lot of doctors do not want arbitration, and the theory is that a jury is less likely to find against the doctor than an arbitrator would. On the other hand, if a jury does find against the doctor, the award is likely to be much higher than if the arbitrator found against him. So it's those kind of thoughts I think you need to keep in mind.
That's great. And then just in terms of the role of mediation, the reason that we laid this part of the program out this way is that there's an arbitration track, there's a court track, and the mediation track really can be imposed on either system. So you could be starting out in arbitration, you could be starting out at the court, and at a point in time, it may be appropriate to go the mediation route. We've talked about the importance of timing of that, the Goldilocks dilemma. Sometimes it's too soon, sometimes it's too late. What factors could determine what is the right time to bring up the mediation? But really keep that option in mind. I don't do arbitration. I don't do courtroom stuff, obviously. I'm not a judge. But I would say probably in 2/3 of the mediations that come to me, especially where I know the attorneys, they'll pull me aside ahead of time and say, Duf, we really respect you, but there's no chance of this matter settling today. We're just here because the judge is requiring it or the contract requires it. And in most of those situations, we end up resolving the dispute. So I would strongly recommend you consider mediation, even if it's not something that's high on your radar. It works out a surprisingly high percentage of the time. Fred, do you have any comment on that?
Yeah, I think, and I've heard others say the same thing, if you have rational clients and lawyers on both sides, the case ought to settle either in personal negotiation or certainly in a well-conducted mediation. Of course, the key to that is when you have people who are being reasonable on all sides, and sometimes you don't get that. People have unreasonable expectations. Perhaps the lawyer gives it to them, or perhaps the client has it, and the lawyer cannot dissuade them. So they don't settle 100% of the time. But I agree, a well-conducted mediation should settle the case the vast majority of the time.
Jerry?
Well, I agree with that is something that's certainly true in today's system. I would say this about the jury system, though, and that is the vast majority of jury cases that actually get tried, in my view, come out on a common sense basis about the way that they should. And that doesn't mean I won all my cases as a lawyer. I've only seen, as a lawyer and a judge over 40 years, one jury case that came out in a way that on a common sense basis it shouldn't have. And so the idea of the jury system, the 12 minds are better than one and are going to meet a better result, and the idea that you're going to get some common sense justice there is something I think to think about when you're just trying to decide, well, do I want to go to an arbitrator on this? And that also applies, in my experience, to commercial business cases as well. I think that's all I'd have to add on that, at least right now.
Well, we're going to go to the next part of the program. Some of you may not be aware of the new technology that we're trying out today. We've developed a partnership with the NSA. And little beknownst to you, while you were thinking that you were only watching something on a screen, we actually had the capability of watching you. And some of you did a great job, and some of you didn't do as good of a job. And your identities are duly noted, and this information has been sent along to the proper authorities. But with that admonition in mind, and the hope that you never end up in front of Judge Buchwald, Roger will throw it open to questions.
Okay, thanks, Duf. Thank you to the panel. This has been really informative and great, and we do have some questions. And let me just go ahead and lead it off with kind of the one big question that is always on everybody's mind when they start weighing the benefits and burdens is what's the difference in terms of cost and time? The conventional wisdom, I think it used to be that arbitrations would cost a lot less and be over with a lot more quickly. But I guess since I've got 3 experts here from different backgrounds, I'd like to throw it out. Is that true? Can you expect to get by a lot cheaper and faster arbitrating as opposed to litigating?
Let me, if I could, start out on that. You know, the origin of arbitrations was something like this. Like you had the diamond sellers in New York City. And you had a whole area of the city where the people did the same business. And there would be a dispute between Joe and Sam about some dealing they had with each other. And so they'd go down the street and get another guy who does the same business. And they'd say, look, Herman, we're going to tell you our arguments here and what happened, and you tell us who's right, and we'll be bound by that, and it'll be over, and we can get back to business. So it started out with that kind of thing in particular trades and based on custom and so forth. Well, over time, it's become heavily, some would say, infected with lawyers and judges and so forth, and started to look more and more like courtroom trials. Some arbitrations have full-blown discovery because they adopt the Code of Civil Procedure, and the discovery is no quicker than in a trial. The hearings will usually be shorter and perhaps more intense, but they should be quicker even today. But it really comes down to what the lawyers and their clients want. If you follow the rules of most providers, such as I know the JAMS rules, they limit discovery quite dramatically. And you can save an awful lot of money that way. However, many times people are simply, lawyers in particular, are really, they just don't feel comfortable about going into a contested proceeding without having had the full discovery. So I know we have created some expedited rules that people can adopt that will get you there more rapidly. And that's important because, after all, you are paying your judge, and you don't have to do that in the public system. So you've got to save time in order to save money to make an arbitration be less expensive. And while it used to be a whole lot less expensive, now it depends on good management to be less expensive.
You know, I'd say that a big factor also is trying to judge how long the proceedings are going to take overall. Court versus mediator versus arbitration. And that's going to depend on a lot of factors. And in our county, if you have a civil case and you come up for the day of trial on the master calendar, you're going to get a courtroom. Last year we got all our civil cases out except one, I think. In another county in the Bay Area, that might not be happening. I remember the come up for trial in San Francisco County, and we'd be there 3 and 4 times before a courtroom was available to try our case, because criminal cases, especially the felony criminal cases, get priority. If there's only 6 trial departments available that day and there's 8 felony cases, there aren't going to be any civil cases that get assigned to a trial department for a trial. And in the arbitration world, generally speaking, you've got a little more constancy on how long the arbitrations are going to take. It's going to be dictated solely by what the subject matter is. And you probably can predict a little better what the overall cost is going to be going in. So that's a big factor that I think just has to be judged on a case-by-case basis. Depends on, where your case is geographically, and what the nature of dispute is as well, for you to be able to get a handle on how long the proceedings are really going to take.
And you know what often happens, Jerry? I'll get a arbitration come in, and we do the disclosures, and we're all set. I'm going to be the arbitrator, and I'll have a conference with the lawyers, a telephone conference. And let's say it was right now, I would say, look, I've got a couple weeks free in November. How about we do it then? And uniformly, what? No way. We can't do that. Our schedules are busy. We got trials and so forth. So we almost always go out 8 months from the very beginning. Now, they could be tried more rapidly, but usually the lawyers that are handling these are busy, and that's simply the reality of their schedules.
Okay, thanks for that. So another common concern, as a business lawyer, one of the things I always struggle with is whether we're going to obligate parties in a contract to arbitrate and have an arbitration clause. And one of the concerns that often comes up is there's a perception that arbitrators are not going to necessarily follow the law. They're going to do what's fair, and doing what's fair will sometimes mean just cutting the baby in half. And I guess since I've got 3 experts from three different backgrounds, I'd ask each of your perceptions on whether that's an accurate perception and whether that's true, or whether that's something we should really consider and be concerned about.
I've heard that many times, and so I have to think that there's some truth in it, but it really depends upon the arbitrator. And when you do an arbitration, I think the most critical decision you ever make is who's going to be the arbitrator. What an arbitrator ought to do is what a judge will do is, make decisions on credibility, decide the facts, apply the law, and rule. And that's it. By splitting the baby, I think the theory is, well, then both sides, they won't love me, but they won't hate me, and maybe I'll get some more business. There's the thing lurking in the background is, I think, a fear that an arbitrator who is privately employed is going to want to have repeat business, and so that will influence the decision. Now, all you can say about that is that should not be the case. Life's too short to do it that way, but I can understand why people would be concerned about that. And probably the only remedy is to make detailed inquiries from other people whose opinions you trust about the qualities of a potential arbitrator.
Fred, I share that concern. This is Duf. That's all I have to say on that, Jerry.
Yeah, I'd agree with what you said, Fred, also, that it really depends. I've seen arbitrators who conduct a hearing more like a trial, who are not going to be necessarily splitting the baby, as has been suggested here. I've also seen the results of arbitrations where there was a compromise result that looks like it was reached because that's what the arbitrator wanted to do. So it just depends on, the person that you choose. The one thing I'd say is that, in the arbitration process, you have the ability to choose that person. In most courthouses, you're going to be in a situation where a judge is assigned, you have in California basically one peremptory challenge to use during the trial level stage of a case if you don't like that judge or you're concerned that that judge will be unfair. So you get the luck of the draw as to who that's going to be.
So Judge, following up on that, one of the questions that came in had to do with the potential or the risk for bias among arbitrators when you got a contract that requires arbitration, and there's a concern that, just exactly the concern that she mentioned. Is there anything that parties can do to protect themselves against that? Maybe I'll
as far as in the provision, well, when you write it?
Well, that's a whole, let's suppose in the question from the audience, there's a provision that was really, it's almost an adhesion contract. It was take it or leave it, and this is our arbitration clause. So now you've got a client that's taken it. Is there anything procedurally that parties can do to protect themselves when they find themselves in arbitration when they might not have agreed to that? If they could go back and rewrite history.
Well, one thing, when you write an arbitration contract, you cannot, of course, give the either party the right to select the arbitrator. It has to be a fair procedure. And when you get things like AT&T or Kaiser or something, if this was in the past, it's not this way today, at least with Kaiser, where they could name the arbitrator. Well, that was an unfair system. That has changed now, and if you so that you have to give usually you have to give each side a fair opportunity in the selection of the arbitrator. Generally, you'll get, if you can agree on it, that's good, that's best. But many times you can't, and if you have an arbitration provider, they'll give you 5 names. You can tell them what kind of qualifications you're looking for. And then you, each side strikes 2. And if you've each struck different ones, you're left with the remaining one. But anyway, a procedure that will be fair is essential for an arbitration agreement to be valid.
You know, I'd add this to what Fred said, and that on this question that's come up, and that is, once you have an arbitration agreement that has been agreed, and sometimes at the start of a dispute, one of the parties will say, you know what, I agreed to arbitration, but I'm not going to consent to the appointment of to the selection of an arbitrator, and I want to go to court on this. And so, you know, as law in motion judge right now, I see from time to time motions to enforce an arbitration agreement, and the parties come in that status and context. In terms of the law on that, there is a great policy in the current case law that favors the enforcement of arbitration agreements. And sometimes there's issues about the scope of what kinds of disputes the parties actually agreed to arbitrate, as opposed to things that are outside the scope of that agreement. But even on that, there have been a couple times when I've found that a particular dispute was not within what the parties contemplated when they agreed to arbitration. And in one of those cases, I was affirmed by a court of appeals, and in another, I was reversed. And so you have to understand that landscape. The other thing is, I mentioned earlier, and I think Fred, you also did, that, and for people that want to look this up, it's in section 1286.2, subdivision 1 of the California Code of Civil Procedure. And this is at the back end that we were talking about earlier, that once you get an arbitration award, you bring it to the court, and it can be confirmed, corrected, or vacated. And under the section I just called out, if an award has been procured by corruption, fraud, or other undue means, that can be a basis for a judge to say, I'm not going to enter judgment on this award. Now, as I said, there is no case law on this other undue means category, no appellate case law. But conceivably, if you were drafting one of these agreements and you were concerned about an arbitrator being one that would be simply splitting the baby and not really hearing the case and deciding it based on the evidence and the arguments, you could write in the contract, I believe, since there's no appellate court definition of what this means, and it's undefined in the statute, you could, with some contractual language, define what this means. The parties could agree that for the purposes of our arbitration, an arbitration that is obtained by undue means and would be subject to being vacated or corrected are the following circumstances. And you could provide in there, I believe, that if you had somebody who really was not deciding the case straight up on the facts and the arguments, that would constitute an award obtained with undue means.
Okay, interesting. Well, thanks very much. I see that we're at the top of the hour. Again, I'd like to thank our panel of experts here. This has certainly been informative. I'd like to remind the audience that this has been recorded. You'll find the full webinar on the Royse Law YouTube site, Royse University/webinars, and also available as a podcast in the iTunes store. Again, I'd like to thank the audience, and I'd like to thank our panel for being here, and we will now conclude the webinar.